Welcome to the International Trade Minute, quick-fire trade news, where time is trade. We are your go-to podcast for rapid and concise updates on trade and law, designed specifically for busy trade professionals. Sponsored by Rydell Law Firm and prepared by seasoned trade attorneys, our twice-weekly podcast packages your essential trade updates, all in the time it takes to enjoy your coffee break. Subscribe now on Apple Podcasts, Spotify, and Google Podcasts, and join the conversation with a network of like-minded professionals on LinkedIn. Where time is trade, make every minute count. In today's episode, we're dissecting a series of pivotal legal decisions and settlements that highlight the complex interplay between trade laws, corporate responsibility, and environmental regulations. Let's get started.
First up, we delve into a ruling that spotlights the intricate dance between legal obligations, corporate responsibility, and governmental enforcement. In a recent decision by the Court of International Trade, the U.S. government was found to have waited unreasonably long, 8 years, to demand payment for an unpaid customs bond from Aegis Security Insurance Co. on Chinese garlic imports that entered the country back in 2004. This decision throws a spotlight on the concept of reasonable time in the realm of customs and international trade law. Judge Stephen Vaden's ruling emphasized that the government's delay breached the implied contractual term requiring demands for payment to be made within a reasonable timeframe. This scenario unfolded against the backdrop of a contentious debate over the classification of Ford's Transit Connect vehicles, a saga that has navigated through various courts over the years, ultimately spotlighting the nuanced nature of tariff classifications and the responsibilities of importers. The crux of the matter revolved around Commerce's former practice of allowing new exporters of goods subject to anti-dumping and countervailing duties to post bonds instead of cash deposits during new shipper reviews, a practice Congress amended in 2015 due to its exploitation by exporters evading duty payments. Aegis issued a continuous bond for exporter Linyi Sanshan Import and Export Co. in 2002, under which the company imported garlic entries from China, only to disappear before settling the dues. The U.S. government's attempt to collect on this bond more than a decade later raised significant legal questions, particularly regarding the timing of such demands. Judge Vaden's analysis dissected the statutes governing the recovery of customs bonds, ultimately siding with the government's interpretation that the 6-year statute of limitations begins from the date CBP issues a bill rather than the date of liquidation. This interpretation, while diverging from a prior CIT ruling, underscores the complexities of customs law and the pivotal role of timely enforcement. Despite the timeliness of the suit under this interpretation, the court deemed the 8-year delay in issuing the payment demand unreasonable, marking a breach of the implied contractual requirement for reasonableness, a principle fundamental to protecting the parties' expectations in contracts. This ruling not only sheds light on the legal nuances of customs bonds, but also on the broader implications for trade compliance and enforcement. The decision underscores the importance of timely government action in enforcing trade regulations and the need for clear guidelines to ensure both importers and insurers can navigate these waters with confidence. As the government and businesses continue to grapple with the complexities of international trade regulations, this case serves as a reminder of the delicate balance between enforcement and fairness, and the critical importance of adhering to the principles of reasonableness and contractual obligations. In this next news, we are looking into a legal dispute that sheds light on the increasingly vigilant stance businesses are taking against forced labor in their supply chains. We're focusing on a recent court ruling involving two prominent players in the fashion industry, Smart Apparel, U.S., and Nordstrom. The U.S. District Court for the Western District of Washington dismissed a lawsuit brought by Smart Apparel against Nordstrom. The crux of the dispute? Nordstrom's decision to cancel orders from Smart Apparel over suspicions that the garments were produced with forced labor, particularly concerning ties to North Korean labor via Smart Apparel's parent company, Zhejiang Sunrise Garment Group Co. This case highlights the complex interplay between corporate responsibility, legal obligations, and ethical supply chain management. Nordstrom's actions followed the detention of merchandise by Customs and Border Protection, which suspected Sunrise used North Korean labor in violation of the Countering America's Adversaries Through Sanctions Act. This act strictly prohibits the entry of goods into the U.S. that are mined, produced, or manufactured wholly or in part by North Korean citizens anywhere in the world. Judge Teresa Fricka, in her ruling, underscored Nordstrom's contractual right to refuse delivery if there was a belief of a violation of the contract's terms and conditions. These included the use of forced labor, engagement with a sanctioned entity, or merchandise not being in compliance with applicable laws and regulations of both the country of origin and the destination. Smart Apparel's defense, that it wasn't directly subject to UC sanctions and that there was no direct indication of its dealings with Sunrise or North Korea, was not sufficient to counter the contractual basis for Nordstrom's refusal to accept the merchandise. The judge's decision leaned heavily on the plain reading of the contract and CBP's public notification regarding Sunrise's violation of U.S. sanctions against North Korea. Moreover, the court's dismissal of Smart Apparel's claims for breach of the duty of good faith and fair dealing and promissory estoppel highlights the legal and ethical responsibilities companies face in ensuring their supply chains are free of forced labor. This case serves as a poignant reminder of the broader implications of international trade laws and sanctions on corporate operations and the global supply chain. As companies navigate these complexities, the emphasis on due diligence, transparency, and compliance with ethical standards becomes increasingly paramount. The Nordstrom versus Smart Apparel case is a bellwether for businesses worldwide, signaling the importance of vigilance against forced labor and the need for robust compliance measures to safeguard against the reputational and legal risks associated with supply chain mismanagement.
Up next, we are diving into a significant legal decision from the D.C. U.S. District Court that touches on the intersection of international sanctions, due process, and the authority of the Office of Foreign Assets Control, or OFAC. The case involves Marceline Mukolo Basengezi, a senior Democratic Republic of Congo elections official who challenged his sanctions designation on the grounds that it was arbitrary, capricious, and violated due process laws. However, the court dismissed his lawsuit, affirming the rigor of the sanctions process.
In 2019, Basengezi was sanctioned by OFAC for obstructing elections in the DRC, a move he contended was unwarranted. He argued that OFAC failed to adequately consider his delisting petition and did not properly engage with the evidence he submitted. Yet Judge James Boasberg ruled that OFAC's denial of Basengezi's petition was not arbitrary or capricious under the Administrative Procedure Act, highlighting that the agency is not obliged to address every piece of evidence submitted by a petitioner in detail. This decision underscores a vital aspect of sanctions enforcement, the discretion OFAC holds in weighing evidence and making designation decisions. While OFAC did summarize Basengezi's claims and structured its memorandum to counter each, the court found that there was a rational connection between the facts found and the decision made, thus fulfilling the legal standard. Basengezi also contended that his circumstances had changed since being sanctioned, arguing that his current activities did not warrant continued designation. However, the court pointed out that OFAC's sanctions criteria could apply solely based on past activities, indicating that ceasing previous sanctionable conduct does not automatically compel OFAC to delist an individual. Moreover, Basengezi's critique of OFAC's reliance on a State Department foreign policy guidance memo was dismissed by the court, reinforcing the notion that OFAC can and does rely upon guidance from the State Department on matters of foreign policy. The case also ventured into the realm of due process, particularly whether Basengezi, as a non-U.S. citizen residing outside the U.S., was entitled to constitutional protections. The court sidestepped a definitive stance on this issue, but concluded that even if due process protections applied, Basengezi received all the process he was owed. This ruling highlights the complexities and challenges of navigating the U.S. sanctions regime, especially for foreign nationals. It serves as a reminder of the broad discretion and authority OFAC exercises in enforcing sanctions, the importance of substantive evidence in delisting petitions, and the intricate balance between national security interests and individual rights. As we watch how this and similar cases unfold, the implications for international relations, sanctions policy, and legal precedent continue to evolve. This episode shines a light on the crucial role of legal frameworks in upholding the integrity of the sanctions process while navigating the delicate terrain of international diplomacy. Last but not the least, we are zeroing into a groundbreaking environmental enforcement action by the Environmental Protection Agency, or EPA, against a subsidiary of a Japanese chemicals giant. Resonac America Inc., part of Tokyo-based Resonac Corp., TITES, has agreed to pay roughly $416,000 to settle charges of illegally importing hydrofluorocarbons, also known as HFCs, into the United States. This marks a significant milestone in the EPA's ongoing efforts to combat climate change by regulating substances that pose a severe threat to our planet. The illegal imports occurred on 3 separate occasions in 2023 at the Port of Los Angeles. What makes this case particularly notable is not just the size of the penalty, the largest of its kind to date against a company for importing superpolluting HFCs, but also the unprecedented step requiring the company to destroy the imported HFCs, a total of over 1,693 pounds. David Ullman, Assistant Administrator for the EPA's Office of Enforcement and Compliance Assurance, underscored the agency's commitment to enforcing regulations against companies that bypass laws designed to protect the climate. This enforcement action against Resonix sends a potent message. The EPA is vigilant in its monitoring of HFC imports and is prepared to hold violators accountable. HFCs are known as superclimate pollutants with global warming potentials hundreds to thousands of times higher than carbon dioxide. The significance of regulating these substances cannot be overstated, given their profound impact on global warming. The EPA and Customs and Border Protection have been actively denying entry to illegally imported HFCs since January 2022, underscoring the federal government's dedication to the HFC phase-down initiative. This phase-down is not just about mitigating climate change, it's also about ensuring a level playing field for companies that adhere to the rules. Illegal imports of HFCs not only undermine the phase-down effort, but also disadvantage compliant companies and contribute significantly to global warming. The settlement with Resonix America Inc. represents a crucial victory in the fight against climate change and serves as a warning to other companies that might consider circumventing U.S. environmental laws. As we move forward, the EPA's role in enforcing climate-related regulations will be crucial in safeguarding our planet for future generations.
Thank you for joining us on International Trade Minute, your rapid source of trade updates for busy trade professionals, and we hope to have you back for our next episode. Don't forget to subscribe.